Welcome to our continuing YouTube video series on employment law. My name is Christopher Neufeld of Neufeld Legal, and in this particular YouTube video, we'll be discussing the importance of adhering to confidentiality clauses when you settle an employment matter. Now, when you look at settling an employment matter, whether it's at mediation, arbitration, or just a settlement that's done at a court, or even through the court proceeding, you want to make sure you abide by all the provisions that you agree to, especially if you are successful in the matter. Now, you might not be as successful as you thought. Nevertheless, if you agree to settle, at that point, you do need to abide by every provision that you put forward. Because if you fail to abide by those provisions, the other side can come back and can look to attempt to vacate the settlement. And that can be very harsh, especially where you're an employee. Well, you were an employee, so you don't necessarily have a ton of money with which you can give up this stuff, especially that you've got a positive agreement. Settling, you might not have the best agreement in the world, but you do have an agreement. And oftentimes, you're having a considerable amount of money coming to yourself. So why do we bring this up? Well, we look at the case of Acadia University versus Acadia University Faculty Association, where the two parties, the university and the faculty association representing one of the tenured professors, had settled their arrangement in mediation. So they had settled, and in the settlement agreement, there was a strict confidentiality clause so that the professor could no longer discuss what happened outside of saying the matter had been settled. The grievance was no longer there. It was settled. Beyond that, this professor was not allowed to say anything further. And then also he was required to remove all social media posts that were negative to the university. And for that, he was going to get a considerable settlement payment. We don't know what that was, but it was to get that payment. And what did he do? Well, he didn't abide by the confidentiality provision, and he continued to post on social media, thereby breaching the terms of the agreement. So what did the university do? What the university should do. Why should someone pay if the other party has breached the agreement? So they went to court. The court adjudicated the matter and said that the university did not have to pay this professor any more on the settlement. And that was because the professor knowingly breached the confidentiality provision. He continued to tweet. He continued to be vindictive on social media. And we see what the court might well do if you breach the terms of the agreement. Yes, the courts tend to be very favorable to the employees as against employers. But if you come to an agreement and the other side has agreed to pay out on the agreement, why would you look to breach that agreement? You're just putting yourself in a bad position, especially when you're creating a record upon which your former employer can act upon and has a basis to say to the court, we in good faith operated with this individual. We sought to come to an agreement. This was the agreement that we both signed off, and especially where both parties were represented by legal counsel, which appears to be the case in this instance. And nevertheless, this tenured professor, who is not your run-of-the-mill unintelligent person, but supposedly very knowledgeable, understanding of what there is expected of them, proceeded to breach the agreement. And at the same time, seemingly thought he should still be entitled to this large settlement amount. And the court said no to that. What did the court say? The court said, you breached the confidentiality provision. You breached the agreement. You're not entitled to any settlement. You've shot yourself in the foot theoretically, and go on your way. Your breach is flagrant. That is what happens when you do stuff like that. So this is the lesson to be learned. If you have a confidentiality agreement in a agreement, especially a settlement agreement, and especially where you've negotiated in good faith and it's signed off and you're receiving what you receive, it doesn't have to be what you would have hoped for at the outset. Everybody hopes for a lot more, but to sell, you have to take back what your expectations are. Nevertheless, you could lose that entire settlement amount. You can lose a lot of other stuff in other agreements. So when you sign off an agreement, make sure to abide by the provisions in that agreement. And don't go out there, blatantly breach it, create a record of it, and not think the other side is going to get upset, take you to court, and try to invalidate their payment to yourself. That is something that you should not be so ignorant as to do, as this particular professor apparently did, knowing full well, or should have known full well, that breaching the agreement is going to have serious repercussions, especially when you're dealing with a university who wants to protect itself and has a right to protect itself. So adhere to your agreements, make sure you're focused on it, and understand what you're getting into when you're settling a matter, and stay clear on it, because it's not going to benefit you from going against what you've agreed to. Well, I trust you found this YouTube video informative and providing you with a degree of insight as to what your considerations should be when you sign off an agreement, and that you should know what's in there, especially when it comes to confidentiality clauses and your obligations under those agreements. Thank you.